But before we go to Mpumelelo Zikalala, who's an attorney and legal analyst, let's take a look at how we arrived at this point. Okay, so that's a timeline of what has been happening. We are joined, as I mentioned, by legal analyst and attorney Mpumelelo Zikalala. So, Mr. Zikalala, thank you so much for taking the time to speak to us. So, talk to us about what a rescission order is, or filing of a rescission is. How different is it to an appeal, and is it unprecedented?
Good evening to you and also to the SABC listeners. You must remember that the Constitutional Court would have rules in which it applies under, or which it conducts itself under. If you look at Rule 29 of the Concord, it then says you can also use Rule 42 of the normal or the high courts that says if you have a certain party in which an order has been granted or a judgment has been granted and they were not aware of the order, they're allowed to come to the court on this road and seek either variation or rescission of this order. Secondly, they can also come to the court if they say that the order in which you have granted as the court is ambiguous, or there's a patent error to it, or there's an omission. There's an important aspect in which you didn't consider, which was presented to you earlier, but when the time came when you're delivering your order, we can see that you didn't consider that particular aspect. Or the last one, meaning that the party which is aggrieved will then say there's a common mistake to the order. We both realize that both parties or both litigants that there's a mistake that has taken place when this order was being granted. Can you, as the court that granted this order, vary or rescind it so that you are able to cure the defect that is there? I must mention, though, that when one is making this application, and I would seem that the former president is making this application based on section or Rule 42, paragraph B, either saying that the order is ambiguous or there was a patent error or there was an omission. And what then seems to be done by the papers that I had been read out is that personal circumstances of the former president are then being presented to the court. But the problem with that is that an opportunity for those mitigating circumstances or mitigating factors was opened by the court, or he was invited to make those. Now, it's a bit too late at this time to say to the court, even though you had provided me an opportunity to present my mitigation factors, I didn't do so willfully. Now, I want to come at this stage after I've seen the hefty punishment of 15 months imprisonment that you are going to give to me. Please allow me an opportunity to present those. Maybe after I've presented those, then you may find lenience and maybe reduce the sentence in which you are going to give to me, or maybe turn it into a suspended sentence.
Now, is this likely to succeed given the reasons that you've outlined and the fact that the former president has said through his spokesperson and legal teams before that by handing down the kind of sentence it has, the Constitutional Court has literally pushed the bounds of the law of contempt in order to meet these exceptional circumstances?
It may have a bit of a problem. This is why I say it. You must remember that if you may go back in history, the former president has been given no less than 3 chances in order to address the court. And on all 3 circumstances or 3 charges, he failed to do that. Now, the problem is that the justification of why we're coming at this late stage after we've invited you a number of times, giving you an opportunity that were extraordinary, where even the Chief Justice wrote a letter to you and said, practically begged you to say, please submit mitigating factors because we need to make a decision pertaining to your conduct. And you wrote back and said you are not going to do that. In addition to that, every time we sit in proceedings, you then issue out a statement saying to us you fully understand the circumstances or the things which are being discussed by this court. So you have full confidence in your statements. You know exactly what is happening to this court, but you choose not to address us. So if on his papers he hasn't dealt with that particular aspect, I don't see this application succeeding.
Now, it's been argued by some that in other jurisdictions, a similar court or similar case before it, there's been a different finding. And I'm going to use Nicolas Sarkozy as an example. The French president was found guilty of corruption in February, but he was given a suspended sentence. So even though there may not be precedents here at home, but could there be precedent outside of our shores?
They could be, and in many a times our courts have sort of borrowed or looked at what the precedent from other jurisdiction is and sort of applied it to us. But you must remember that when the Concord issued this judgment during the week, it explained why it was looking at these exceptional circumstances, so to say, by saying to the former president, even though you are a citizen of this country, we must hold you in higher regard because you've shown your allegiance twice to the rule of law and also to the court of law. So you're a prime example of how a leader should be. You have led this country before, hence you should lead by example, not only when you are in office, but even when you are outside of office. Now, if we are going to have a former leader not adhering to the rules of this court or to the orders of this court, what is going to happen to an ordinary person who is basically just an ordinary citizen? So if you are not going to show your support and your respect to this court, we must issue a sentence in which is going to be a prime example of how we deal with people that don't adhere to court orders. Hence, which is why we are giving you this particular sentence.
Is the Constitutional Court compelled to make provisions for this matter to be heard, and will the Zondo Commission have the right to oppose it?
Because it's coming in as an urgent application, there are then 3 requirements of urgency, meaning that there must be a right which must be protected. I think we'll be able to pass on that one. Secondly, there must be irreparable harm if the matter is not heard today. On his papers, for sure, he would have written that I'm going to go to jail on Sunday. If not, 3 days later, the police will come and arrest me. So I am going to suffer harm. And lastly, there are no alternatives that I can go to, as there's no other appeal court that I can go to because the matter was heard at the Apex Court of South Africa. Hence, the Constitutional Court judges are the only ones that can be able to hear this application. But while we are hearing this application, can you please suspend the operation of the order that you issued earlier? So it certainly can buy him time in terms of going to jail on Sunday or maybe during the week next week. But another point which will matter is whether the chances or the prospect of success are there. And when you look at it, if you read Rule 42 and the provisions that are there in previous case law, the chances of that are very slim because it was a matter that was taken by the majority. He was open, or he was given ample opportunity to come and represent his side of the story or present his facts. All that he's raising now could have been raised within that particular mitigation or in mitigating of his sentence, of which he voluntarily chose not to. So the court would then say, we've given you ample chances. We have taken this decision after we've thought of everything and all the legal principles that are there, and we still feel that it is the appropriate one.
Okay. Now, just finally, the Jacob Zuma Foundation denounced Judge Khampepe's judgment as judicially emotional. I know it was a full bench, but it pointed to her specifically, but it said that the judgment was judicially emotional and angry and not consistent with our constitution. I'd like to hear your thoughts about this because we're led to believe that the judiciary makes decisions on the basis of law. So is it possible to have an emotional judgment, should I say?
I don't think so, because whatever that the court is going to present or forms part of its judgment, it is basically law. You may have or find a few harsh words here and there, but the intention within this case specifically is to send a message to the members of the public of saying, us as the court of law, we regard ourselves as very important in terms of maintaining rule order in South Africa. Hence, we don't take kindly to people that don't listen to us, especially when we've given them chances to come and present their side of the story in seeking to preserve or to promote their constitutional rights. Now, after being given all those opportunities and they were still snubbed, the only way in which we can assert our effectiveness and assert our order, ensure that we are indeed there to preserve law and order, we must be able to provide these hefty sentences. So I don't think that it was written in a harsh manner, or it was maybe in a way or in a language that is unbecoming when it comes to judgments. It was just an ordinary order, just that the court wanted to make it clear that it doesn't take kindly to people that are not going to listen to it.
And those who agree with you, Mr. Zikalala, have said that scores of letters were sent to the former president informing him that he's been named in testimony before the State Capture Commission, and that there were numerous summonses sent before criminal contempt charges were laid against him. Thank you so much for speaking to us. Mpumelelo Zikalala is an attorney and legal analyst. Let's take a quick look at your weather prediction.